in the grand scope, in the smallest little microcosm, you're a coward.
He stabbed her so hard and so violently that he left a knife through her neck. The children were present and witnessed this incident.
A woman linked to a murderous gang in Cape Coral, currently serving a life sentence for the torture and killing of 2 teenagers, is not seeking a reduction of her prison sentence. Ashley Toye was one of 10 individuals, most of whom were teenagers, convicted in the deaths of Jeffrey Sosa and his 18-year-old uncle, Alexis Sosa, 9 years ago. A recent court ruling could potentially give her a second chance at life outside prison.
I loved him. I thought I loved him.
Ashley Toye informed the judge about her toxic and unhealthy relationship with Kamar Johnston, the ringleader of the group convicted of brutally killing Jeffrey and Alexis Sosa.
I was stupid. I was a coward.
Now 26, Toye stated that she takes responsibility for her actions and feels ashamed of carving symbols into the back of Jeffrey.
You regret having done that? Is this something on your mind constantly?
It's constantly. I hurt him.
Although the state is not opposed to a sentence reduction, during cross-examination, the prosecutor ensured that Toye remembered the torturous and horrific nature of the crime by showing her graphic pictures.
And Jeffrey Sosa was screaming at the time.
Toye did not look at the pictures as she answered the questions.
They didn't just murder my cousin and uncle, they tortured him.
Andrew Sosa, who did not attend the hearing, stated that it is still difficult to think about the deaths of his family members 9 years ago.
My cousin and uncle, they're buried. You can't dig them out the grave and bring them back to life.
Again, I like the forgiveness of the Sosa family for what I've done.
Andrew stated that he is opposed to Toye receiving a reduced sentence.
It'll be a while before you can ask for forgiveness from us. It'll come, but we'll never forget it.
He believes that time will help the Sosa family heal. A man convicted in the shooting death of a Milwaukee teenager will remain in prison until he is at least 80 years old. Police reported that Demario Jackson shot into a crowd during a fight, resulting in the death of a teen. The judge described the weapon Jackson used during the incident as a weapon of mass destruction, and the sentence he received was harsher than what the state prosecutor had requested.
The court on count 1 is going to impose a life sentence in the Wisconsin State prison system with eligibility to apply for extended supervision in 56 years.
First came the sentence, followed by a family's cry of anguish. Demario Jackson will remain behind bars until he is at least 80 years old. A jury found him guilty in the shooting death of Japhet Moore. According to police, Moore was at 12th and Locust in the summer of 2013 when Jackson opened fire. Both Jackson and his attorney maintained his innocence. Jackson provided a very brief statement before the court.
I want to say sorry to the family for them going through this. I don't think no one should go through this because I don't know how I feel to happen to my kids. I don't think my family should be going through this either. And I just hope that they get what they ask for, justice.
The judge stated that Jackson's sentence served as a message to him and the entire community.
It's just not going to be tolerated in this county. And individuals who do commit these type of offenses are going to be punished severely.
Jackson is 25 years old and a father of 7. Jackson's gunfire also struck 2 other teenage boys and a woman in her 20s, and they are in recovery. Caitlyn Armstrong, a former yoga instructor convicted of murder, is receiving a lengthy sentence following an emotional trial. After escaping to another country, trying to change her identity, and even attempting to escape from jail, she will ultimately spend the rest of her life in prison. Armstrong was sentenced to nearly a century behind bars.
This court hereby sentences you.
Former yoga teacher Caitlyn Armstrong was sentenced in a Texas courtroom to 90 years in prison for murdering professional cyclist Anna Mariah Mo Wilson, whom she believed was romantically involved with her then-boyfriend, Colin Strickland.
We, the jury, find the defendant, Caitlyn Armstrong.
After the judge handed down the guilty verdict, Taryn Wilson testified during the sentencing phase about the profound impact of her daughter's death.
When you shot Mariah in the heart, you shot me in my heart.
During a trial that lasted 3 weeks, state prosecutors presented a disturbing portrait of Caitlyn Armstrong, who shot Anna Maria Mo Wilson in a jealous rage in May 2022.
The last thing Mo did on this earth was scream in terror. Those screams are followed by "Ah! Ah!"
Armstrong's vehicle was captured on video near the scene of the murder. She fled to Costa Rica, even undergoing plastic surgery, in an attempt to evade authorities.
I've never seen so much evidence in my life against one person.
The jury took less than 3 hours to return their verdict after prosecutors established that Armstrong ambushed and killed Wilson. The Wilson family walked arm in arm outside the Austin courtroom, feeling relieved that justice had been served.
Selfish manipulation, jealousy, and hatred never lead to positive outcomes.
This was an incredibly emotional trial, during which prosecutors highlighted the testimony of Wilson's close friend, who discovered her body. She recounted her efforts to revive Wilson. A man who shot and killed a passenger in another car during a road rage incident will spend the next 60 years in prison. The victim, 31-year-old Eli Hickerson, was murdered while heading home from work. It was an emotional day in the courtroom where multiple family members of Hickerson shared their grief. After the sentencing, the family expressed that no amount of justice could bring their son back.
You have a child and you can protect him for so long, and then the world takes over. We just don't have our Eli anymore. The 60 years that he did get is never going to be enough, and we're never going to be the same again.
A road rage incident claimed the life of 31-year-old Eli Hickerson, leaving his family and the world grieving. A judge sentenced Dion Kimbro to 60 years for Hickerson's murder. Many witnesses testified about the profound impact Eli Hickerson's loss has had on their lives.
In the grand scope, in the smallest little microcosm, what was you going to get out of it? You're a coward!
After a 3-day jury trial, Dion Kimbro was convicted of murder and unlawful possession of a firearm by a serious violent felon.
And that coward shot my boy in the back and then claimed self-defense.
Kimbro's family also took the stand, asserting that he was not a monster and highlighting that he has a son who misses him back home.
And we'll just continue to be the family we are to honor my son's memory.
Kimbro is appealing his conviction, and the court has issued a no-contact order. After standing trial for murder charges for the second time, Erica Stefano was found guilty of aggravated murder for luring her then-husband's ex-girlfriend to her death. Ashley Biggs, a pizza delivery driver, went to work in Akron in June 2012 and never returned home. Summit County prosecutors allege that Stefano placed a fake pizza order to lure Biggs to a parking lot where she was beaten and strangled to death by Chad Cobb, her ex-boyfriend and the father of her child at the time. Biggs and Cobb were involved in a bitter custody dispute over their daughter, and Cobb was married to Stefano at the time.
The answer I was hoping for, and the answer I do in my heart, because God will prevail. Justice has prevailed, and my daughter can finally sleep. She won't hurt her no more.
Stefano admitted to making the fake pizza delivery call, but continued to claim that she had no involvement in the murder. She is scheduled to be sentenced. An appeals court had previously overturned her murder conviction in the death of Ashley Biggs, leading to the retrial. One of 2 women accused of beating another woman to death remains in jail, with police stating that the fight was over a man. Authorities revealed that the 2 women recorded a video of the attack and used their own words against them in court. Police say they used the man's cell phone to lure the victim to the location, where she was ultimately beaten until she could not breathe. The suspects, Janine Gonzalez and 27-year-old Antonetta Stephen, are accused of murdering Ashley Bocanegra by beating her to death. Police allege that Stephen initiated the fight, and Gonzalez joined in because Bocanegra was involved with Stephen's boyfriend.
Started standing over her, and she asked Miss Janine Gonzalez, "Do you want any of this?" Which Miss Gonzalez replied, "I do," and she came and kicked her about 3 times on her side.
The fight caused internal bleeding in Bocanegra's lung, which, according to the medical examiner, ultimately led to the young mother's death. Police report that Gonzalez's brother is at the center of the love triangle, and she recorded Stephen fighting and making threats on her cell phone.
You could clearly hear her say, "I'm going to murder you," about 5 times. Are you ready to die? And I could do worse.
Janine Gonzalez began her court appearance in tears as the county police officer laid out the murder charges against her. The report states that she and her 27-year-old aunt, Antonetta Stevens, are accused of using cell phones to lure Ashley Bocanegra to the scene of the fatal attack. Gonzalez's attorney argued that she was practically a bystander, asserting that the real fight was between Stevens and the victim.
Given that, I think the case ought to be bound over as involuntary manslaughter and not as felony murder.
The officer testified that one of the last texts Ashley Bocanegra sent was to Gonzalez's brother, in which she stated that she couldn't breathe.
I was fine until your sister kicked me in the chest and back area.
Both women accused of this murder will remain in jail with no bond. It has been a year and a half since 22-year-old Amaya Chennault was killed in a crash in northeast Fresno. The man behind the wheel, John Ashcraft, was scheduled for a preliminary hearing, but instead opted to change his plea.
At the house.
Amaya Chennault's family continues to keep her memory alive following her tragic death in April 2023.
She has a lot of great, memories, a lot of good friends that still keep in contact with us and make sure that, we know that she was loved.
Chennault's life was cut short when her car was hit while turning onto Frant Road from Shepherd in northeast Fresno.
We'll never see her again.
The incident was captured on video by Daniel Wells, a resident of the area. Fresno police reported that then 53-year-old John Ashcraft ran a red light on Frant Road in a tow truck and collided with Chennault's car. He pleaded not guilty, but later changed his plea to no contest.
And you understand, I'll accept your no contest pleas, but I'll use those no contest pleas to make a finding of guilt.
Yes, Your Honor.
Chennault's family is grateful to be one step closer to closing the case.
It's been a long road, almost a full year that he's been in custody. We've, of course, been dealing with it about a year and a half, but it's nice to see justice finally being done. Almost where he's accepting responsibility for what he's done.
Ashcraft's defense attorney stated that his change in plea reflects his remorse over the crash.
It's a little hard because I don't feel like he's shown remorse. He doesn't. It's not that we want some type of acknowledgement, but his facial expressions kind of show a lot, and it's tough to see.
In court, Ashcraft admitted that he was high on meth and did not have a license at the time of the crash. He is scheduled to be sentenced on October 30th for multiple charges, including felony gross vehicular manslaughter while intoxicated and felony DUI causing great bodily injury. Ashcraft faces a maximum of 10 years in jail and a $10,000 fine. However, the judge indicated that the court will likely impose a midterm sentence with a maximum of 6 years. The woman accused of hiding evidence in the murders of a mother-to-be, Savannah Soto, and her boyfriend, Matthew Guerra, is now $500,000 closer to being free. A judge drastically reduced the bond for Mira Romanos just a month after she was charged with the case. Shackled and dressed in a county-issued jail jumpsuit, the 47-year-old made her first appearance in state district court. Romanos is charged with 3 felonies, accused of assisting her son, Christopher Preciado, and her husband, Ramon Preciado, in moving the bodies of Savannah Soto and her boyfriend, Matthew Guerra, to a Leon Valley apartment complex just days before Christmas. Police have stated that the younger Preciado killed the couple during a drug deal gone wrong. Romanos' attorneys argued that her bonds totaling $1.1 million were excessive and were being used by the district attorney's office to punish her or keep her in jail while awaiting indictment. They requested that the bonds be reduced to $250,000.
Objection. There's no evidence of any actions of hers. This is a bond hearing for her. I understand he wants to grandstand for them. That's great. But this is not the venue for that.
Judge Miguel Najera heard evidence from both sides before reviewing several exhibits behind closed doors, including a graphic photo taken at the crime scene. After returning to the bench, the judge determined that he would not agree to reduce Romanos' bonds to $600,000, meaning she would need to raise around $60,000 to post bail. Whether Romanos can afford the reduced bond amount remains to be seen, as she testified that she has been struggling to pay her mortgage. Additionally, her husband and son are still in Bexar County Jail. During the sentencing for the death of a girl, a brawl erupted in a Detroit courtroom when the girl's father attacked Clifford Thomas, the man responsible for killing his daughter. Dwayne Smith, Jamila's biological father, stood up to give a victim impact statement and then began yelling and punching Thomas, who was awaiting his sentence. The courtroom was cleared, and the proceedings were rescheduled to follow the incident. Jamila died in September 2014 after her mother, Jasmine Gordon, and her boyfriend, Clifford Thomas, rushed her to the hospital. Authorities reported that the girl had bruises that were consistent with abuse. Later that day, Gordon was sentenced to 14 to 25 years for a child abuse conviction and 7 to 15 years for manslaughter. Thomas received a sentence of 4.5 to 15 years for manslaughter and 1 to 2 years for resisting arrest. Francisco Uriarte had been on the run for 4 years, living in Mexico until he was extradited to the U.S. He appeared before a judge for the first time, facing accusations of murdering his wife. Now 41 years old, Uriarte is in a navy blue San Diego County jail suit, charged with child endangerment and murder for allegedly stabbing his wife, Natalia, to death in their Chula Vista apartment in March 2020.
He stabbed her so hard and so violently that he left a knife through her neck. The children were present and witnessed this incident.
Deputy District Attorney Aaron Casey stated that while the children were not physically harmed, their father fled, leaving his kids behind with their mother, Natalia, who was a makeup artist.
As he fled, he was picked up initially by a cousin. That cousin ultimately refused to take him across the border, but did observe him making phone calls. One of the people that he called had been connected with the victim, and he left a voicemail indicating that he would as well.
Casey did not disclose the motive for the murder, but provided insight into the situation involving the man who was threatened. According to the investigation, the incident occurred after Uriarte discovered that his wife was speaking with that man. He had an interpreter in court who denied the allegations against him. The murder took place shortly after the pandemic shutdown began.
This was a unique case in that the murder actually occurred during COVID-19, and the courts were actually closed at the beginning. The Department of Justice and our office worked as quickly as we could to work with Mexican authorities, but ultimately it takes time.
The judge determined that Uriarte is a flight risk, setting no bail and approving a protective order that prohibits him from having any contact with his children.
Children are safe. They've been safe and secure since the time of her murder.
Natalia's family was not present in court, but many of the suspects' family members attended. They declined to comment. Uriarte's preliminary examination is scheduled for January 29th. A Fulton County judge sentenced a man to life in prison for killing a woman he met on a dating app.
It's one of the hardest crimes to make sure that we combat.
Fulton County District Attorney Fonnie Willis stated that her office is proactively contesting domestic violence cases.
This is an issue that is really close to home for me.
This initiative is part of the Brenda Bam Domestic Violence Unit, named after Willis's late aunt, who was ultimately stabbed to death.
Stabbed her to death in the back.
Members of the unit spoke after the defendant was sentenced for the 2019 murder of Fabiola Thomas.
This is a really sad case.
Her life mattered. She lived with purpose.
A Fulton County judge sentenced Antonio Wilson to life in prison without the possibility of parole for malice murder.
She unfriended Antonio Wilson the day before she died.
Senior ADA Charles stated that text messages reveal Wilson's inability to handle Thomas's rejection before he killed her inside her Roswell apartment.
My sister was attacked and murdered in her home.
Investigators found that Thomas and Wilson had only dated briefly after meeting on a dating app. Attorneys indicated that after Thomas rejected his advances, Wilson tracked down her address and attacked her in her home.
Was a surprise attack. She did not know her attacker was coming that morning.
Jurors reached a guilty verdict in just 30 minutes after viewing crime scene photos and hearing from Thomas's roommate.
She only met him in public places. She would even meet him outside of friends' houses in parking lots. So it is very scary because Ms. Thomas did everything that you would, want to do.
Wilson displayed very little remorse during the sentencing, declining to speak or make any statements during the hearing. Jerome Allen, sentenced to death, returned to a Brevard County courtroom seeking a reduced sentence. His murder trial gained significant attention in 1991 as the victim was the father of a girl. During the hearing, that girl returned to speak dramatically to the judge, raising the question of whether Allen might someday be released from prison. Now 37 years old, Jerome Allen faced the family of the victims for the first time in court. He shot Stephen DeMont in 1990, while he and his friends stole a few packs of cigarettes and some money from a convenience store. Allen was originally sentenced to death for the murder and received a life sentence for the robbery. However, the Supreme Court overturned the death sentence due to Allen's young age at the time of the murder and mandated that he be given a fixed term of years instead of life for the robbery. After hearing from the daughter of the murdered father, who never knew him, the judge sentenced Allen to 45 years for the robbery.
And the fact that he's here today with the chance to get out of jail, I mean, it's very frightening. So today I hope that justice is served and he stays in jail.
We will be.
Dumont was only 2 years old at the time of her father's death. Jerome Allen has received a life sentence for Stephen Dumont's murder, with the possibility of parole in 3 years. For the robbery, he was sentenced to 45 years, but according to the rules in place at the time of his sentencing, prosecutors indicated that he would likely serve just half of that sentence. This means he could potentially be released in about 25 years. One of 3 men involved in the 2022 killing of a St. Paul man in an alley near his mother's home has been sentenced for his role in the crime. In December 2023, a Ramsey County jury found 20-year-old Dewan Allen guilty of aiding and abetting second-degree murder with intent while acquitting him of a separate felony second-degree murder charge. During the sentencing hearing, Judge Yang allowed Allen to address the court, asking if he had anything he wished to say.
All right, Mr. Allen, you do have the right to address the court. Anything else you want to add besides what your attorney told me?
I want to send my condolences to Alex Baker's family. I'm sorry. I'm sorry for your loss. I didn't have any knowledge that these events would occur. Deep down in my heart, I believe that your significant other was an innocent man and did not deserve to lose his life.
During sentencing, Judge Yang delivered a pointed statement about the nature of the crime. From the outside, it might appear to be a robbery, but when you look closer at the evidence, it's as if you were hunting. You chased your prey, surrounded him, and used him as target practice, the judge remarked.
All right. With that, Mr. Allen, we did have a trial. The jury convicted you of count 1, which is second-degree murder with intent, and the court, if not done so, will adopt that guilty verdict, adjudicate you guilty of that count. Related count 2, which is the felony murder, that's you are acquitted of that, so that count is dismissed at this point. So we're going to proceed to sentencing on count 1. And Mr. Allen, I have sat through the trial. I hear the testimony. I consider the argument that the attorney had made. I consider the statement that the family had provided to me. And to the family, I just want to thank you for being here to provide statements, to share with the court as well as the state about who Alice Becker is and what he means to you, what he means to the state. So I appreciate that. I don't know if this will be a closure to you, but hopefully he will bring accountable to the people that was involved in this incident. So whether that's a closure or not it's a phase that you go through. And again, my hope is that we'll bring accountable to the people that are involved in this case. So again, I appreciate the time that you took to be here and also provide the statement to the court. And Mr. Allen, I did see a lot of evidence in this case. Even prior to this actual incident, the state present evidence, video, surveillance video of you at the apartment complex. And almost every time I saw you, you also cover your face with a skiing mask sort of cover every time. When you're indoor, when you go to the elevator, when you go open the door for someone. when you go to the store. There's only a few times that you take off the mask that the state is able to present your actual face. And the mask is not your typical, concern about your health mask where you cover your nose, your mouth. It's only cover it doesn't cover your nose wide open. It just cover everything else. You can only see your eyes and your nose. And it's harder to identify you that way. And I think that goes into why you put yourself in this situation. You're always ready to get involved in criminal activity. I think that's the only reason why you constantly cover your face at the store, everywhere. Not concerned about your health and covering your nose way exposed the whole time. So what led to this night? The night that Else Becker was killed, the state will summarize the facts. And all murder cases are senseless, including this one. And a lot of the time, however, at time we're able to categorize as gang-related shooting murder, robbery shooting murder, drug deal gone bad shooting murder. Could be domestic, assault-related murder, shooting. From the outset in your case, it was like a robbery shooting. And I say from the outset. But when we look deeper into what happened in this case, as the state summarized the fact already, I don't need to do that. Appeared that you were driving around the city, looking for someone to do something with someone. I think that's the only purpose you do when you're just driving around in the city in the middle of the night. And as soon as you spotted Else Becker walking home that night from work, you were the driver, you in charge of that car, you decided to stop, park the vehicle, and you led the chase of Mr. Becker. And as the state summarized the facts, before as he's walking toward, as soon as he turned from the street to the alley, which is his house on the second house on that alley block, you are the first one who chased them. You led the chase. You made sure your co-defendant were with you. And within seconds of that chase, we heard the gunshot. And again, as the state's already put those facts on the record. From the sound of the gunshot it does appear that you have plenty of time. 4 shots were fired, then there's a pause. Then another 3 shots were fired, then there's another pause. There's one more shot. And that showed me that he's not fighting back. You and your co-defendant keep shooting him. Take your time to shoot him. You're not in a rush. Usually people in gang-related shooting, they fire as they run. You guys didn't even run. You keep shooting at him. Take your time. So that showed me that is even beyond an execution. He's your target practice. Because you took your time. And you fire at least 7 shots at him. Take a pause in between. And again, we look deeper. You clearly have your time, the 3 of you. The police found his wallet. It's all cash in it. Not a whole lot of cash, but clearly he has money in his wallet. You didn't touch it. You didn't want the cash. So from the outset, it looked like a robbery. But when you really look closer at the evidence, It's like you guys are hunting. You chase down your prey, you surround him, and you shot the prey as your target practice. And this is a human being we talk about, Mr. Becker. Not only, as the state again point out, not only you let the chase, let the kill, you also let the escape. You got in the car first, and the other two guys just running like deer in a headlight. They don't know where they run. We saw the video. They run back and forth the same spot. Not until you pick them up that they're able to get away from the scene. So the court clearly see that you play a more significant role in this murder. You actually let the chase, let the getaway, and you will deserve the most punishment as required by law.
Judge Paul Yang sentenced Dewan Allen to 367 months in prison, equivalent to approximately 30.5 years. With credit for the 444 days he had already served, Allen is set to spend most of his life behind bars.
So based on your conviction, guilty verdict, the court's going to order you serve, commit you to the commissioner to serve 367 months. With that, 2/3 had to be served in custody. The remaining 1/3 may be served in supervised release. You'll be given credit for 444 days. The court's going to grant the restitution, the federal expense restitution. The court's going to grant Ms. Becker's request for restitution amount, and the court further is going to keep restitution open for 90 days from today's. So additional restitution will be submitted for consideration. And of course, rather have any money you have go toward the restitution. I'm not going to issue any fine. There'll be a surcharge of $86 in this case. Again, I want the restitution to pay, and that's why I don't assess any fine. I believe that DNA sample already on file, so I don't have to order that. Missing anything further?
Your Honor, I think that covers it. You are ordered both restitution requests. Right. I believe that's everything.
Mr. Plesher?
Would Your Honor waive the public defender fee?
If there's a fee, I'll waive the public defender fee as well. I'd rather have the money go toward the restitution. So, all right, with that, the sentence is concluded. And if for the family going to leave the courtroom, please follow the direction. The deputy, they're going to tell who to leave first, so just don't get up and follow the direction. And with that, the sentencing on Mr. Allen's case concluded.
Authorities allege that on December 27, 2022, 3 men attempted to rob and ultimately killed 22-year-old Alex Becker in a dark alley behind his family's home. The tragic incident occurred just steps from his mother's door, where she heard the gunfire that took her son's life and saw 2 suspects fleeing the scene. Prosecutors initially charged Dewan Allen, Sean Travis, and Artiz Kennard with Becker's murder, asserting that all 3 men were in the alley and acted together when the crime occurred. However, Sean Travis was acquitted in his first trial after District Court Judge Japal Harris, presiding over a bench trial, found him not guilty. Artiz Kennard entered a guilty plea to aiding and abetting second-degree murder. Meanwhile, Dewan Allen's defense attorneys have filed for a new trial, pointing to Kennard's testimony, which indicated that Allen was not directly involved in Becker's death, evidence that was unavailable during Allen's trial. Kennard's sentencing is scheduled for a later date. An Akron woman, Elma Gray, has been sentenced to prison by a Summit County judge after firing gunshots at her own son during a heated dispute. According to investigators, the incident occurred in April 2019 when Gray threatened her son during an argument. When the boy locked himself in his bedroom, Gray attempted to force her way in by firing multiple shots through the door. Thankfully, her son was unharmed and no injuries were reported. After the shooting, Gray fled the scene but was apprehended shortly after returning to her home on Ganyard Road. She faced several charges, including domestic violence, aggravated assault, and improper discharge of a firearm into a residence. Following the incident, her son was placed under the care of Summit County Children's Services.
Individual will need to be masked And we will need to keep some physical distancing, but as you can see, we do have plexiglass, et cetera, for purposes of COVID protocols. All right, I did order a pre-sentence investigation in this matter. I do have that report, and I believe that both counsel have received that report. Is that correct, Ms. Jackson?
Yes, Judge.
And Mr. Siplin?
Yes, sir.
Mr. Siplin, do you have any corrections, additions to that pre-sentence investigation?
No corrections or additions at this time, Your Honor.
All right, very good. Then I believe that we are prepared to proceed with sentencing. And I will turn to the state for that purpose.
Thank you, Judge. Judge, we did file a sentencing memo, so I'm not going to go over the whole thing. I know you've read it and reviewed it. The state is requesting 6 years of ODRC. I believe that is appropriate in this case. It's a felonious assault. There was a firearm involved. Although we dismissed the specification as part of the plea deal, you know, this is a very serious offense. The victim was the defendant's son. He was a minor. He was a teenager. He was afraid for his life. He thought he was going to die when his mother was shooting at him.
Ms. Jackson, if you could talk into the mic.
Yes, Judge. And, you know, she shot 3 times. This wasn't a warning shot. It was through the door. If you're trying to scare someone, I would imagine you would shoot at the ceiling, but she was shooting through a door towards her son. And, you know, I'm thankful that we're not here for a murder trial. For the reasons stated in the sentencing memo, state is requesting a period of incarceration. Judge Michael Gray, who is the father of the victim, is present with his attorney Leslie Johns, and I do believe at the appropriate time they would like to address the court.
All right, and I think that now at the appropriate time, I would ask that whoever speaking stands at the podium. Sometimes I would have you approach, but given plexiglass and mic issues, if you could stay at the podium and speak.
At the sentencing, the victim's father, Michael Gray, expressed his outrage in a fiery statement directed at the child's mother. "You have no idea how much anger I carry, and you won't truly understand it until the day you die," he said. "I will haunt you for the rest of your life. You should consider yourself lucky that you're still breathing."
Good afternoon, Your Honor. Leslie Johns on behalf of Mr. Gray and his son, Mateo Gray. Your Honor, I've had an opportunity, unfortunately, to be involved in this matter since the date that this happened, which was on April 29th of 2019. I received frantic messages and calls from my client, Michael Gray.
I'm going to object to Mr. Gray's attorney speaking on his behalf, because even under Marcy's law, I do not think that it carries a provision that a representative should be doing it. Anything that's said should come directly from Mr. Gray and not through a proxy.
Judge, I believe Marcy's law states that parents of child victims are also considered victims in the case, and victims are permitted to have their interests represented by an attorney, and they're allowed to support, they're allowed to file motions on their own behalf. And so I think Ms. Johns speaking to the court is appropriate.
The objection will be overruled. Ms. Johns, I don't know that your involvement is relevant. I mean, the fact that you received calls may not be relevant, but I think you can speak on behalf of the victims.
Thank you, Your Honor. What I was getting at is not to what I experienced, but what my clients experienced on that particular incident. I got a phone call from my clients frantically indicating what had happened on this occasion. They certainly had no idea what to do, in what direction to turn in. And since that time, over 2 years ago, I would just note for the record that my clients have been impacted day in and day out, not just by general court proceedings, but and the pendency of this matter, but by the fact that what occurred on that particular night is a traumatic event, which I think that nobody in this room would disagree. This is something that goes beyond this court proceeding. This is something that my clients will have to deal with for the rest of their lives. I personally have never been shot at, and so I can't speak to how that might feel. But certainly coming from the position in which Ms. Gray was in at that particular time, the mother, the guardian, the legal custodian, as my client was out of state.
This attorney is talking about her personal experience, and she wasn't a victim. She's just a representative for them at this juncture.
Yeah. So the same kind of admonition that I gave before. I understand where you're coming from, but overruled. But if you can keep it focused on the victim.
Yes. So I am speaking on behalf of Mateo Gray. He's not here today to speak for himself because he does not want to be in this courtroom. Understand.
We can see that he doesn't want to be here. It's just.
So I will note that I do have victim impact statements from both Mateo and Michael Gray, but I do believe that under Marcy's law, he can have a representative speak on his behalf. So go ahead.
Thank you. The reason why he's not here today is I know from speaking with Mateo myself that he is significantly impacted by this offense. He cannot really wrap his mind around or truly understand, as the victim impact statement notes, how to address or deal with the thoughts and the feelings that he has because he was placed in harm's way by his mother, his parent, his guardian, his protector. He would like the court to know, as he indicated in his victim impact statement, that this is something that will follow him for the rest of his life. He's going on to college here soon. We're hoping, and he's hoping, that the mental health services that he has been receiving since this incident occurred, he'll continue to do so and be able to move past this. However, today, I think, as my client will speak to the court, is one step in the direction of being able to move on, though this is something for them that they will have to deal with and reflect on for the remainder of their lives. And so, Your Honor, I would at this time like to allow my client, Michael Gray, an opportunity to speak.
Mr. Gray. Thank you, Your Honor. I wanted to thank the court, the prosecutor's office, and my attorney for being there and protecting my son in children's services as well. I want to address Elma directly. The amount of anger and hatred I have towards you for what you did knows no bounds. I will be back in this court every 5 years and make sure that protection order stays in place so my son is protected. You won't understand the amount of anger I have until the day you die. And I will haunt you for the rest of your life. What you did to him, just be thankful you're still breathing.
And Judge, Your Honor, as we indicated as my clients indicated in their victim impact statements, they have specific requests as to the appropriate amount of time. Certainly, my client is asking for the maximum period. I did go over with them the prosecutor's recommendation and what they are requesting the court to do, and Mateo Gray has no objection to that request. Your Honor, we would ask that you take into consideration the victim impact statements and the ongoing impact that this offense will have on them in the future. Thank you.
Eddie Siplin, Elma Gray's attorney, supported for probation by emphasizing that mental health struggles and a lack of support influenced her actions. Siplin also highlighted that Gray had taken accountability for her behavior. During the proceedings, Gray expressed her remorse. "I love my son more than anything in the world, but I still can't fully remember what happened."
Your Honor, may it please the court, the reason that we're here today is that, one, Ms. Gray has accepted responsibility for her actions, and this is truly a matter of where I don't think that this was a criminal case, but a case of crying out for help on Ms. Gray's part. The court has reviewed the psychodiagnostic reports and knows the significant mental health history, but during the time period, I think, of what really pushed her over the edge was the lack of having a supportive helpmate, husband, partner, father, and what have you. As was indicated in Ms. Gray's PSI statement, she was offering by way of an explanation and not necessarily an excuse, in that, one, her family was going through financial help, her relationship with her husband, Mr. Gray, was on the rocks, and especially after he had given her an STD, her life was falling apart, and she had the mental health.
There's an objection.
It's in her
But
PSI.
It is in the PSI as a statement of Ms. Gray, so go ahead.
And so she is under that pressure, and along with the pressure of the possibility, in addition to not living the happily ever after, she found out that her husband was the still same miserable person that he was when she originally left him, but she believed in trying to have a family. He was the only man that she had ever known, but her world was falling apart. And as such, this was her cry for help, because I know one of the things that she had asked Mr. Gray for help, it pretty much said, well, if you kill yourself, you kill yourself. It's no skin off of my thing. So she had no one, no resources, and it was a cry for help. And I do not believe that she intended in her mental state to harm her son. I think it was more of a cry for help and to get attention. And there was some, she had a mental health breakdown. While we know that from the evaluation she may not have met the legal standard under NGRI or for the competency evaluation, but what we do know is that she has a significant mental health history. As a matter of fact, I know that she had been hospitalized upon occasion, as well as, what came out is that, both she and her husband have had their own bouts with mental health issues. But even when you look at the statements of Mr. Gray, you could hear the hate and anger that he has towards his wife. And my impression of it wasn't because of what she's done, it's because of other underlying deep-seated issues. But what I can represent to the court is that Ms. Gray deeply regrets the actions of that day. And she's living with the fact that due to her mental health issues, that she could have not only harmed herself, but she could have harmed her son, which that action in and of itself has caused damage that she and her son, once he gets out from under his father's thumb, will have to work on their relationship. But as indicated by the nature of the plea, it's one of the things that, she accepted responsibility. And it's one of the things that in order for the people to move on, and especially their son, and whom she's more concerned about, I don't think that a prison sentence would be necessary. I mean, the concern is for Mateo, but imagine the impact that of his mother sitting in prison, knowing that a lot of the actions on that day stemmed from her mental health issues, not from a purposeful manner in which to do it. Now, and I would ask the court to follow the recommendations as indicated in the PSI and place Ms. Gray on a period of community control. She does not have a criminal record, but for this and maybe some other little minor traffic stuff, there's nothing on her record that would warrant prison. But what is warranted and what we do have within our community are the resources available to help her get the mental health treatment and counseling that she needs. This matter stemmed not from a criminal intent, but from a mental health intent. And part of the court's role is to balance those things. And I think with over the past 2 years, it's been devastating to Miss Gray to know that she, due to her mental state, that she could have possibly harmed her son. And that, to me, I think from my conversations with her, is the scariest thought in her mind regarding all of this, that she could have hurt her son. She, quite honestly, had an intent to harm herself, and thankfully she was not successful. But what we would respectfully ask, Your Honor, is to look beyond each of these parties' hate for each other and look at what we can do from the good we can come out here. Yes, there's a price to pay, but the price is not necessarily with Miss Gray losing her freedom, but the price is being sanctioned by the court to commit to getting mental health treatment and following the recommendations there. She's not a threat to this community, and we would just respectfully ask the court to follow the recommendations as indicated in the pre-sentence investigation report.
Before handing down the sentence, the judge gave Elma Gray the opportunity to speak, asking if she had anything she wanted to say.
Ms. Gray, is there anything you would like to say to the court prior to your sentencing?
We stand here.
Right there.
I love my son more than anything in this world, and I still can't recall exactly what happened. Just the thought of it could have been murder was, I can't accept that myself. I'm working on it. I love him more than anything, and I am so sorry I stayed in a toxic situation that was
Judge Tammy O'Brien acknowledged Elma Gray's mental health struggles with sympathy, but ultimately sentenced her to a minimum of 4 years in prison. The judge emphasized the severity of the situation, remarking that it was only by sheer luck that this case did not turn into a murder trial.
Well, I will say to everyone, obviously this is a very tragic situation involving a family that now has ongoing issues. I'm sure had issues before, but whether this has any chance of being repaired is to be seen in the future. These are the kinds of cases that really are some of the most difficult that are presented to the court, where you have an offender with no criminal history and then a very serious offense as their first infraction. That's a difficult situation. It's a difficult balance for the courts to undertake, and fortunately for the court, there are guidelines, there are statutes, there is the law that must be followed. I will first note that in a felony of the second degree, there is a presumption for prison, and Mr. Siplin has talked about rehabilitation and et cetera, and I would just note that that is only one of the two reasons that this society may commit someone to prison. There's rehabilitation, but there's also punishment. There's also protection of the victims and the community. Some of the things that it is incumbent upon this court to consider are, would community control or something less than a prison sentence adequately punish the defendant and protect the public from future crimes? Whether the sentence is proportional to the harm caused and the impact on the victim? Whether something less than prison would demean the seriousness of the offense that was committed, and also whether a firearm was involved and whether there was a threat of serious physical harm to the victim. In fact, in this case, I think everyone would acknowledge, Ms. Gray too, that we are all very lucky that no one was hurt, that no one was killed. We could just as easily been here on murder charges, which would be exponentially more tragic than where we are today. So with all of that in mind, I have considered what Ms. Johns has said and Mr. Gray on behalf of the victims, the pre-sentence investigation, the victim impact statements, the plea negotiations, statements of counsel and the defendant. I have, for purposes of the pretrial proceedings, obviously, and then again, more recently reviewed the several psychological evaluations that were done in this case. There is some history of mental illness, of depressive disorder, borderline personality disorder, etc. But legally, Ms. Gray was found to be sane and competent. She knew the wrongfulness of her actions as indicated by several factors, but also in the disposal of the gun and some other actions on the night of the incident. So having considered all of that, based upon the facts and circumstances of the case, in consideration of the relevant sentencing factors, and applying the minimum sanction the court has determined will protect the public, promote the rehabilitation of, and punish the offender without imposing an unnecessary burden on state or local resources. On count 1 of the indictment, would note that this is an indefinite sentencing case under Reagan-Tokes, and therefore the court would impose a sentence of 4 to 6 years incarceration for the crime of felonious assault, a felony of the second degree. So the minimum prison term would be 4 years, and the maximum prison term would be 6 years. As we discussed when I took your plea, you will also be subject to a mandatory 3-year period of post-release control following your release from prison. When that period of post-release control is imposed, if you violate any conditions of that supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. Would note that the sentence is right in the middle of the guidelines for prison that could be imposed in this matter, and because it is her first offense, because of some of the mental health issues, I find that that is an appropriate sentence. Ms. Gray, there is a rebuttable presumption that you will be released from prison at the expiration of your minimum term of 4 years or on your presumptive early release date, whichever is earlier. If the Department of Corrections seeks to hold you longer, they may rebut the presumption that you will be released at the expiration of 4 years. If at a hearing the department shows that your actions in prison demonstrate a lack of rehabilitation or that your behavior demonstrates that you continue to pose a threat to society, or that you were placed in extended restricting housing, that your actions demonstrated a lack of rehabilitation or that your behavior demonstrates that you continue to pose a threat to society, then the Department of Corrections could seek to hold you longer. Or if you were placed in extended restricted housing at any time during the year preceding the hearing, or that you were classified as a security level 3 or higher at the time of the hearing. If the department overcomes the presumption, it may keep you longer than the 4-year minimum term, but no longer than the maximum term of 6 years. You are also eligible to earn a 10 to 15% reduction in your sentence if you exhibit exceptional conduct or adjustment to incarceration while in prison. I'm not going to impose a fine. Judgment will be rendered against you for court costs. You will be given the opportunity to pay those costs on a payment schedule, and if you're not able to do so on a timely basis, you could be ordered to do community service in order to satisfy the cost judgment. I do have 4 days credit for time already served in the Summit County Jail. And Ms. Gray, you understand that you do have the right to an appeal in this matter within 30 days after the filing of the court sentencing entry. Do you understand that, ma'am? Can you verbalize your response, please? And you understand that if you are unable to pay the costs of a transcript, the record, and all relevant documents that are required for the appeal, that they will be provided to you without cost. Also, if you're not able to pay for the appeal, you are entitled to have the notice of appeal filed without the payment of a filing fee, And if you are unable to afford counsel for an appeal, counsel will be appointed for you without cost. You understand that, ma'am? All right, anything further then for the record this afternoon?
No, Judge, thank you.
Mr. Siplin?
No, Your Honor, but we would respectfully ask the court to allow Ms. Gray 2 weeks to turn herself in. She's currently treating, part of her job, treating patients, and there needs to be a transition with that. Throughout the pendency of this matter for the past 2 years, Ms. Gray has made every court hearings, whether it was in person or via video. We just ask for that accommodation. And a lot of that stems from what we know was part of the recommendation from PSI, but she just needs that time so that her employer patients are not left in lurch.
Ms. Jackson?
Judge, this case is over 2 years old. Ms. Gray has had plenty of time to be out, and I request that she be taken into custody.
I agree. I believe that she should be remanded to custody to begin her sentence at this time. Thank you.
In July 2021, Elma R. Gray received a prison sentence of 4 to 6 years for charges that included felonious assault and endangering her son. While the court recognized the gravity of the incident, the sentence reflected some leniency, as this was Gray's first criminal offense. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.